Okay, Mr. Carter is before Judge Simpson for multiple domestic violence charges, including strangulation. Let's check it out.
The cases of the people versus Camus Carter.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Carter as to both matters.
Kamal Carter.
Chris Clare on behalf of probation. Your Honor, Mr. Carter scheduled before the court for a review hearing. This review hearing got put over. At the last review hearing, the court was aware that Mr. Carter had potentially had a new case coming. That case has been entered now in its status. I know that Mr. Carter did attempt to walk in to address the warrant. However, doing so, indicating that he had to turn himself in to take care of that. Given that he is before this court today, probation is asking that the court address that felony warrant. This court also did put a GPS tether on Mr. Carter, including the victim in the new pending case with an exclusion zone for her address. So he does have a GPS tether on in the case that's before the court today for the victim in the new pending felony.
All right, with reference to that case, Mr. Burgess, anything?
Which case? The review case or the new case, Judge? Which one?
The review case.
Sorry, Judge.
No, it's okay.
Yeah. Obviously, you know, under the I would just note the review case. We understand we did obviously the review case. I think that my client, other than I understand there's new criminal conduct, I think that he's been compliant other than that. And I thought the new charges were domestic violence charges. I didn't know if they were felony charges or not. Was it a G?
Yeah, well, I think what I'll do, hearing no objection, I will just continue as conditions on the old case and I'll set a violation of probation hearing for November 4th, 2024 at 1 p.m. because of the new charges. So I'll follow that recommendation because that seems to me to make sense on that case. Are you going to represent him on this one?
I think if I didn't file one, I will, but I thought I filed an appearance. We did contact the court to try to walk him in for this. My client contacted him.
You filed a warrant recall request, but no appearance. Request denied, instructed him to turn himself in at Washington County Jail.
If I didn't, Judge, I will. If there's not one in there, I will file.
Well, yeah. Used to be that we would let counsel know.
Yeah, that would have been nice, but I thought if I did, if I didn't, if there's not one in there, I'll file it. So.
All right. Are you aware of the charges on this? So he has the assault with intent to do great bodily harm, less than murder by strangulation.
Okay.
The 10-year felony. And then domestic violence, second offense, so 1 year.
Okay.
Did you wish any further reading?
No, Your Honor, we would stand mute as to charges. Didn't waive any further reading.
Defendant having waived for reading, standing mute, court will enter not guilty plea. I'll set a probable cause conference in this matter for, I can do the 17th or 24th, counsel. Which
the 24th is preferable, Your Honor.
All right, you waive any timeline?
Yes, Your Honor.
Set probable cause conference for October 24th, 2024, 9 a.m. As to bond.
Your Honor, I would note to the court, obviously he's appeared voluntarily. We did attempt a couple efforts to walk him in before today, but we tried to get a warrant recalled, which was not successful. But obviously my client was made aware of these charges a while ago. It's obviously appeared voluntarily. The court knows his history of obviously appearing when he's required to appear by this court. I would indicate to the court he made, substantial. It's a reminder, Judge. I know you know, but he walked himself back into the Washington County Jail when requested. And I don't believe he's a flight risk, Judge. As far as danger to the community, he's on a GPS tether. The woman in question, this incident happened at his workplace. It did not happen at a residence at the Target, specifically on Waters Road, Judge. I do believe that there are some bond conditions to avoid to comply with safety to the community, Judge, that you can obviously have exclusion zones with that GPS tether. Understand, obviously, he's on probation to you, but other than this new offense, which he's presumed innocent on, that he's obviously been compliant with the other conditions of it. Other than that, Judge, I would ask the court to consider, if not a personal bond, a low nominal 10% bond in this matter, considering his appearance in court.
Ms. Lundy.
Your Honor, this time that the defendant committed this offense or committed this offense, he was on bond with the following convictions awaiting sentencing: assault with intent to do great bodily harm less than murder or by strangulation, felonious assault, carrying concealed weapon, reckless driving, resisting or obstructing, and domestic violence second offense. He had already pled to those charges, was awaiting sentencing on September 17th. He had failed to appear for his scheduled circuit court probation interview prior to that sentencing, and his sentencing was then adjourned. Furthermore, he was on, of course, misdemeanor probation to this court, as this court is aware, for the child abuse fourth conviction. In this case specifically, part of it, people do understand, did occur at the target, but the other part of it that happened before related to the defendant accusing the victim of cheating on him and then pouring his coffee all over her head. The victim responded by throwing the mug at him and then pushed her up against the wall, wrapped his hand around her neck and squeezed her neck. The victim told the defendant the relationship was over. She was packing his bags. He threatened to slash her tires, put sugar in her gas tank. The victim brought the defendant's belongings to him at work, and while she was there in her vehicle, the defendant reached in and tried to take the keys out of the car, and she ended up with a cut to her finger in that incident. We are requesting a $100,000 surety bond in this matter.
And Judge, just a couple of things that people noted. There was we did reschedule the sentencing, and it was a more of a scheduling thing than anything else, Your Honor, as it relates to not showing up for his plea. But he did show up. He's due for sentencing tomorrow in front of Judge Kunke, and that pre-sentence report.
He did show up for what?
Your Honor, he did show up for the rescheduled PSI interview. The pre-sentence report has been completed. He is due for sentencing tomorrow in front of Judge Kunke. The initial interview date we had to reschedule due to a scheduling issue was my point, Judge. We rescheduled with Judge Kunke. There was zero issue with it, Judge. They gave me a new date and a new interview date. So, Judge, as it relates to the pending charges, when we were in front of Judge Kunke, Ms. Landy actually extended the offer to my client to offer a plea. That plea comes with no upfront jail time. That was the offer extended by the people. So
this case,
on the pending charges that Ms. Landy just indicated, she's actually the APA that extended the offer to my client to plead on those cases with an agreement of no upfront jail time. So the people were not seeking any further additional incarceration on those pending charges where he's due in court tomorrow for sentencing. But obviously they were not overly concerned with his freedom at that point, because they obviously offered that plea deal, Judge, when they made the offer to have him plead in federal court, or excuse me, circuit court in front of Judge Kunke. So I do believe, Judge, that based on that, I think that I understand the nature and seriousness of these charges, but he is still presumed innocent, and I do believe that he will reappear in court. And again, the tether can be, have exclusion zones on it. So.
And for the record, Your Honor, that plea offer and that sentence agreement was months and months ago. So it was before any of this new case that just happened a couple of weeks ago. The last time that he was up for review, I did request the remand, and the court let him remain at liberty, I believe. And at this point, in the arraignment on the new matter, I am requesting that $100,000 surety bond.
the victim worked at Target. I'm trying to figure out why this occurred at Target.
He works at Target, yeah.
She bought the belongings to his work because she said that the relationship was over, and then there was another physical altercation in the vehicle, is my understanding. That ended up, he tried to take the keys out of the vehicle, and she ended up with a cut to her finger.
Is there a rationale as to, I mean, I'm not saying whether it's correct or not, that she brought those to his work? I guess
Obviously, we think we have a different version of what happened, Judge, but I'm not trying to litigate it in front of you right now. So,
Ms. Lundy, any
reasoning as to why she brought the items there?
right? I mean,
My understanding was that she wanted to end the relationship and bring his things that were in the home.
So was she residing in Ann Arbor?
I'm not sure where she's residing at this point, Your Honor. I can look in just 1 second and see if I'm able to give. And Your Honor, for the record, On September 23rd, I'm sorry, excuse me, on July 23rd, 2024, I wrote a note in his felony file that indicated that the defendant did not complete his PSIR. He was not remanded, and the case was adjourned to September. And then on September 3rd, the case was then adjourned a week because Mr. Burgess wasn't present for the sentencing, I believe.
That's correct.
There. And then it got adjourned again to accommodate Mr. Burgess' schedule, of course. We always try to do that. So as far as the new case and where that victim is living, my understanding is that she lives in Ypsilanti.
And drove all the way to Waters Road. I mean, that's what I'm trying to figure out. I mean, I understand the people's allegations in it, but my concern is it's not as though he and as I have it, that doesn't necessarily make any sense. I guess the factual allegations are a bit problematic in the sense that I'm not, what I read from the prosecutor's statement is that he leaves for work. I guess, were they residing together?
Yes, Your Honor.
Leaves from work, and then I guess she contacts him at that point.
She comes after he's already at work and working, Judge. He's already checked in for, or is already logged in for work. She comes up there. Obviously, our position is that with an intent to make a big scene, and that's what's initiated.
Well, that's kind of what I'm trying to figure out, because one of the things that's missing from what the people told me, but was on the sheet, is that he leaves for work. Then, and again, I don't want to litigate it, but that she contacts him to let him know.
Yes, Your Honor.
Yeah, to come outside.
And I will say that.
Well, but hold it, that's different though. Because what's being said here is that somehow she contacts him, as I'm reading it, while he's on his way to work.
Oh.
Or
Yeah, it would say
maybe he's at work and she contacts him.
What I read, I believe, was after the defendant left work, the victim told him their relationship was over and she was packing his bags. And that's when the threats to slash the tires and the sugar in the gas tank were made. And I'll say the police report I'm reviewing does not indicate that they lived together. It actually specifically says they do not reside together, but they were both at the location in Ypsilanti when this first incident happened. And then he went to work at Target. I apologize for anything.
Okay, well, I'm just trying to figure this out because the way I read this, I did again. The way I'm reading this is he leaves from work. At what point does she contact him? On his way to work?
he had already.
While he's at work?
Right.
That part I'm not sure.
Well,
He had already made it to work with his on his way, but I know that she contacted him to say things were over and she was bringing things, packing up things, excuse me.
Right. We're saying while he was at work, she reached out to him, knowing that she knew he was at work, Judge. She knew his shift. So obviously she's reached out to him while he was at work to indicate.
And you're saying, Ms. Lundy, that he's not residing at the Ipsy address?
That's according to the police report I have. They don't, it says they do not reside together. The exact quote from the Pittsville Township Police report that I'm reviewing says, dating 1 year, no shared children. Matlock and Carter do not reside together.
They just happened to be together that day before. Is that the deal?
My assumption would be that they were together on that day at the location in Pittsville Township on Glen Hill Hills Drive, which I do believe to be where the victim resides.
When you reside in Towner or no?
In Russell Street in Cincinnati.
Pardon?
I'm at Russell Street.
Now,
Yes, sir.
but on the 14th of September, where were you living?
I was with her. We actually lived together. We moved up here and we've been living together ever since.
She's originally from Kentucky, Your Honor.
Well, I don't think we're gonna be able to figure it out. I guess one of the things I'm taking into account is that, and I don't know the living circumstance, but she says he's packing his things up. Well, hold on. Is she's still at that location, or we think?
Right now,
Yeah.
I'm not sure. I don't think so. I don't know where she's living right now.
This makes no sense to me because that's an apartment on Glencoe.
Yes,
Right.
yes, Ron, that's correct.
Right there.
So if they weren't, I mean, is it the people's position she was fleeing for safety is the reason she's not there, or this apartment doesn't exist? Or is it, I mean, if she rented an apartment, whose apartment was it?
She indicated to the police it was her apartment. He did not speak to the police, is my understanding, when they entered their investigation.
Okay, which he has a right to. So,
Correct.
but she's saying that's her apartment,
Yes, sir.
but we don't know if she's there.
I don't know if she's still there. I understand she's told our office it was also her apartment, but I don't know if she's still residing there. It would be an assumption that she is, that she was her apartment, but I don't know for sure. I don't have actual information about that one way or the other.
Well, the parties agree that somebody doesn't get an apartment for a month. So either she's there or she's not. Because he has a prohibition from going there. So whose apartment was it? Who leased it?
It was her.
Hers.
She leased it,
Yes, sir.
but you were living there.
Yes, sir.
If it's anything else.
No, Your Honor, thank you.
No, Judge.
Well, I think the problem here is going to be that I don't think a $100,000 bond is an appropriate bond in this case. I mean, if they were residing together, I guess I'm unclear as to even if the version of events is true that she let him know he was packing his things, that she could have come up there and just left them there. She could have left them outside the apartment. She could have done a whole bunch of other stuff other than bring them to his employment. So that may not excuse his alleged reaction, but still, the more problematic thing for the court is that this occurs or is alleged to have occurred on September 14th. That it also at the time the defendant is on probation to me, but also he is pending sentencing in another matter in circuit. And that's a problem that you're involved in at least alleged criminal activity at this point in time. But taking that all into account and looking at it, the court does believe that a bond in this matter, given the defendant's conduct, would be required. However, until we can get to the bottom of this, I'm going to set his bond at a $25,000 cash as surety bond. I would $25,000 cash surety bond. I would indicate that and Mr. Carter, we're going to indicate that you're not to leave the state of Michigan without the permission of the court. You are to not to purchase any fire, ammunition, or other dangerous weapon. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. I'm going to order that you have no contact with Jennifer Matlock, either directly or indirectly. You understand that, sir?
Yes, sir.
That means also no contact through any type of electronic communication, including but not limited to phone, email, texting, internet, or social media. You are also not to refer to her on social media or in any electronic context in any manner whatsoever. You understand that? I am also going to indicate that you are not to go to the 22. You're not to go to the Glencoe Hills complex at all. You understand that? I'm going to prohibit you from the entire complex because, quite frankly, that complex doing an apartment doesn't make much sense. In Pittsfield Township, you're not to violate any criminal law. You're to personally appear at all court hearings as directed by the court. You are to remain on the GPS tether as you've been given in the other matter. You understand all of that, sir?
Yes, sir.
All right. It's done, Mr. Carter. I'm going to ask that you go with my bailiff. We will see you on the 24th, if not before then.
And Judge, I just want to ask, would the court possibly consider a 10% provision on the bond?
At this time, I'm not going to do that. I would. The problem is, and I appreciate, and just to state this for the record, because when I released or let him go the last time, I didn't hold him just on the complaint itself. I gave the defendant credit because he had walked into the court. I didn't know much else about the circumstances, but did give him credit because he will turn himself in and he complies with this court. It doesn't seem to be an issue. However, I can't ignore the fact that at the time now that these charges have come down, that at the time of that, there's two things that are on this defendant. One, my probation, and the other thing, the pending sentencing in the other matter.
Just all right.
Okay.
All right.
Thank you.
And Your Honor, I want to clarify with the GPS tether. Are you ordering the GPS on the new case, and can it be removed from my case since my case doesn't involve that victim? Or are you ordering it kept on my case?
I'm ordering it on both cases.
Okay.
Because I'm not clear on, I mean, at some point I have to get some clarity as to what all of this is about. But
Okay, because my victim is a different victim.
I'm aware of that.
Okay, okay. Just want to make sure.
Yeah.
If I could put two tethers on him, I would, but I can't. So
I've had it done with clients, Judge.
yeah, no, I
Different
can't.
jurisdictions, but I've had it done. Yeah.
Yes.
So,
All right.
Judge, he just want to leave some valuables with me before he's going to custody. Is that okay?
That's fine.
Okay. All right. I'll just hold on to it. So you don't.
I need one of the orders.
All right.
Copy.
You can go with the deputy. So.
Well, I think Mr. Carter had that one coming. If you like this video, give me a like, give me a subscribe. Till next time.